Welcome to this Nigerian Intellectual Property Law podcast. My name is Ogunesan Olaitan. Today, I will be diving into the Domitilla case, examining the key issues that arose and the implications for intellectual property law in Nigeria. You may know Domitilla as a classic Nigerian movie title from the 90s, but in recent years, it became the subject of a heated trademark battle between actress Anne Njemanze and veteran filmmaker Zeb Ejiro. So, what happened and what does this case tell us about trademark law in Nigeria? The story begins in 1996 when Zeb Ejiro produced the Nollywood film Domitilla. The movie became hugely popular, spawning a sequel in 1999 and remaining a cultural reference point for decades. Han Njemanze, who starred in the title role, gained recognition as the face of Domitilla. Fast forward to September 2020. Njemanze went ahead to register Domitilla and device as a trademark at the Nigerian Trademarks Registry. That registration gave her, on paper, exclusive right to use Domitilla in connection with entertainment and related services. But there was a shocking twist to this whole story. Ejiro, the producer, objected, claiming that the goodwill in Domitilla belonged to him as the creator and producer. After all, the film has been marketed, sold, and circulated for decades under its control. He argued that Njemaze, though the lead actress, had no legal claim to the name itself. This objection led to proceedings before the Trademark Tribunal, presided over by the Registrar of Trademarks. Several questions came before the tribunal. First, who actually owns the goodwill in the name Domitilla? Is it the filmmaker who created and marketed the film, or the actress who played the role? The second question was was Njemanze's registration filed in good faith? Or was it an opportunistic move to capture a name she knew was already famous and associated with Zeb Ejiro's work? Thirdly, did the registration contradict Section 11 of the Nigerian Trademarks Act, which prevents registration of marks that can deceive the public or that the applicant has no distinctiveness in? And finally, the last question, did the registrar have the authority to revoke a trademark that had already been registered if it was wrongly granted? Let's examine the tribunal's decision. In May 2023, the tribunal delivered its ruling. It held that the goodwill in Domitilla clearly resided with Zeb Ejiro, the producer, who had used the title for nearly 3 decades. The tribunal stressed that acting in a film does not give an actress or actor independent right to the film's title. Njemanze, therefore, had no goodwill in the name Domitilla. The registrar also found that her application was made in bad faith. She knew of the history of Domitilla and its association with Ejiro, yet still sought to register it. This conduct fell under Section 11 of the Trademarks Act, which prohibits deceptive or dishonest applications. Finally, invoking its statutory powers, the tribunal cancelled Njemanze's trademark, stating that it had been issued in error and should never have been granted. So, the question now is, was the tribunal right? I think so. Trademarks exist to protect the origin of goodwill and to prevent confusion. In this case, the goodwill attached to Domitilla did not belong to Njemanze. It belonged to the creative mind and producer who had marketed the film since the 90s. The tribunal's reliance on bad faith was also correct. One of the biggest threats to trademark systems worldwide is opportunistic registration, where someone tries to capture a mark they know is already established by another. Nigerian law, like many others, rightly discourages that. And on the registrar's powers, the Trademarks Act allows the correction of errors. Yeah, in this case, cancellation was simply the correction of an error. Now, does this ruling conform with intellectual property law? Absolutely. The decision is consistent with both Nigerian and international principles. Section 3 of the Trademarks Act preserves the action of passing off for unregistered marks, while Section 11 prevents deceptive or dishonest marks. Common law systems across the world agree that you cannot register a mark in bad faith or without genuine goodwill. Now, is the Nigerian intellectual property law adequate in the ruling of this case? We can say yes. This case shows that Nigerian law is capable of handling modern disputes. The Trademarks Act provided the right tools, grants for refusal, protection of goodwill, and powers of cancellation. That being said, there are several areas for improvement. First, public awareness is low. Many creatives, like actors, do not fully understand intellectual property ownership. The law could also benefit from clearer procedural guidelines, especially on how to prove bad faith or goodwill in practice. But overall, the Domitilla case proves that the law works when applied diligently. In conclusion, the Domitilla case reminds us that trademarks are not just about names, they are about goodwill. Goodwill belongs to those who create and sustain it. The tribunal's decision was fair, firmly rooted in law, and it strengthens confidence in Nigeria's intellectual property framework. For lawyers, creators, and students, the lesson here is simple: understand your rights, protect your creations, and respect the goodwill of others. Thank you for riding with me on this episode. If you enjoyed this discussion, don't forget to share this podcast with fellow law enthusiasts. Once again, I am Ogunesan Olaitan. Until next time, stay curious and stay informed.